Major breaking news in the fight to protect your Second Amendment rights. A recent unanimous 9-0 decision from the United States Supreme Court. Yes, unanimous is now being used as a powerful tool to challenge and potentially dismantle state-level so-called assault weapon bans. And while this decision wasn't directly about rifles, the language used by the justices could mark a turning point in the legal war over firearm ownership in America. We're going to break it all down. How this ruling connects to the California rifle ban case, why it matters, and what comes next in this battle for our constitutional freedoms. For years, states like California have tried to ban certain semi-automatic rifles by labeling them assault weapons, not based on how they function, but on how they look. If your rifle has a pistol grip, flash hider, or collapsible stock, suddenly it's illegal. These laws don't target crime, they target law-abiding gun owners. At the heart of the legal fight is a simple question. Do these bans violate the Second Amendment? According to recent court decisions and constitutional history, the answer is becoming clearer, and a Supreme Court ruling may have just tipped the scales even further. Let's dig into the California case that's now at the center of this legal storm, Miller versus Bonta. This lawsuit directly challenges California's so-called assault weapons ban, a law that doesn't outlaw rifles based on how they work, but on superficial features, things like a flash hider, a telescoping stock, or a vertical foregrip. If a law-abiding citizen owns a semi-automatic rifle with any of those characteristics, California classifies it as an illegal assault weapon. The case was first heard by Federal District Court Judge Roger Benitez, who ruled in favor of the plaintiffs. His decision was clear. California's ban violates the Second Amendment. He cited the text, history, and tradition framework established by the Supreme Court in District of Columbia versus Heller and reaffirmed in New York State Rifle and Pistol Association versus Bruin. Under that standard, modern-day bans on commonly owned firearms fail constitutional scrutiny. But the fight didn't end there. California appealed the ruling to the Ninth Circuit Court of Appeals, where the case hit a wall. Like many Second Amendment cases, Miller was delayed, put on hold while the court waited for a ruling in a related case, Duncan versus Bonta, which challenged the state's ban on so-called high-capacity magazines. After Duncan was finally decided in California's favor, Miller began to move forward again. Now, with oral arguments completed and supplemental filings submitted, the Ninth Circuit must decide, will it follow the precedent laid out by the Supreme Court or continue defying it? Here's where things get interesting. In a completely separate case, Smith Wesson versus Mexico, the Supreme Court issued a 9-0 ruling that, on its face, wasn't about the Second Amendment at all. The core issue dealt with whether gun manufacturers could be held liable under Mexican law for crimes committed with their products. The court said no, but here's the kicker. The language used by the justices may have just cracked open the door to ending assault weapon bans nationwide. In that ruling, the court emphasized that firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. That may sound like a throwaway line, but in legal terms, it's dynamite. Why? Because under Heller and Bruin, firearms that are in common use and used for lawful purposes are categorically protected by the Second Amendment. This wasn't a divided court. It wasn't a narrow 5-4 ruling. It was unanimous 9 justices, across the ideological spectrum, agreed on this point. That gives the language serious weight. Even if it wasn't the main issue of the case, it reinforces and updates what the court has already said in previous gun rights decisions. And now, that very language is being cited in the Miller versus Bonta case. Plaintiffs challenging California's assault weapon ban are pointing directly to the Smith Wesson decision as proof that rifles like the AR-15 are indeed protected under the Constitution. In their supplemental brief, they argue that this Supreme Court language isn't just opinion, it's binding authority. Whether courts agree with that interpretation or not, one thing is clear. This decision has added a powerful new weapon to the legal arsenal of gun rights advocates, and it couldn't have come at a more pivotal time. So how exactly are gun rights attorneys using the Supreme Court's words to take down assault weapon bans like California's? It comes down to one core legal principle, common use. According to the Supreme Court, going all the way back to District of Columbia versus Heller, the government cannot ban firearms that are commonly owned by law-abiding citizens for lawful purposes, like self-defense. That principle was reaffirmed in Bruin, and now strengthened again in Smith Wesson. The plaintiffs in Miller versus Bonta are seizing on this. Their legal argument is simple. If AR-15s and similar rifles are in common use, then California's ban is unconstitutional. Full stop. They're not arguing around the edges. They're going straight at the heart of the ban. California can't claim that AR-15s are dangerous and unusual when the Supreme Court just described them as widely legal and commonly owned. That distinction matters because only dangerous and unusual weapons fall outside Second Amendment protection. And with millions of AR-style rifles in circulation and actively used for home defense, training, and sport, the common use test seems clear. This isn't just theoretical. Courts don't like to directly defy the Supreme Court, especially on a 9-0 ruling. The moment something is seen as settled law, lower courts are supposed to follow. That's what makes this legal strategy so effective. It's not about introducing new ideas. It's about holding the courts to the standard the highest court already laid out. In other words, Smith Wesson isn't just a corporate liability case. It's become a wedge, a legal crowbar. And the more it's cited in Second Amendment litigation, the harder it becomes for states to justify keeping their rifle bans intact. Now, let's talk about the Ninth Circuit and what's really happening there. The oral arguments in Miller versus Bonta made one thing painfully obvious. Not all judges are interested in following Supreme Court precedent. In fact, some seem openly hostile to it. During the January hearing, judges on the panel repeatedly mischaracterized the AR-15. One referred to it as a machine gun. Another called it an A-15, demonstrating a shocking lack of technical understanding. And it wasn't just ignorance, it was biased. Judges expressed skepticism that these rifles are commonly owned in California, even while ignoring national ownership numbers in the tens of millions. One judge went as far as to suggest that common use doesn't apply if a particular state has fewer owners, completely missing the point of constitutional rights. The Second Amendment doesn't change based on zip code. That logic would mean a right exists in Texas, but not in San Francisco, which is absurd and legally indefensible. This isn't just academic, it's defiance. Despite clear guidance from Heller, Bruen, and now Smith Wesson, these judges are looking for ways to sidestep the obvious. Whether it's downplaying Supreme Court language as dicta or pretending statistics don't matter, the game is the same. Stall, confuse, and delay. And that's exactly what they may do. Instead of issuing a ruling in Miller, the panel might simply hold the case, again, until another one, like Duncan versus Bonta, moves through the system. That's the tactic. Keep everything in limbo while pretending the legal questions are unsettled. But they're not unsettled. Not anymore. The Supreme Court has spoken. And every day that a lower court refuses to listen is another day the constitutional rights of Americans are denied not by law, but by deliberate judicial resistance. This isn't just about California. What's happening in Miller versus Bonta, and what the Supreme Court said in Smith Wesson, has national implications. If AR-15s are in common use and therefore constitutionally protected, then every state-level assault weapon ban in the country is standing on borrowed time. States like Illinois, New York, New Jersey, and others have passed similar laws, often using nearly identical language. They're all built on the same shaky foundation, rebranding widely owned firearms as assault weapons to justify banning them. But if the courts apply the Constitution faithfully, those laws cannot stand. The Smith Wesson decision gave more than legal cover, it gave momentum. Plaintiffs across the country are citing that ruling as a hammer to drive home the argument. These rifles are not rare, they are not exotic, and they are not outside the scope of the Second Amendment. They are normal, they are lawful, they are protected. But here's the catch. Some courts will comply with that reasoning. Others, like we've seen in parts of the Ninth Circuit, will try to sidestep it, hoping that delays and conflicting rulings will allow bans to survive just a little longer. That creates what's known as a circuit split, where different federal appeals courts issue opposite rulings on the same constitutional question. And when that happens, it practically guarantees Supreme Court intervention. We may be approaching that moment. Whether it comes from California, Illinois, or New York, one of these cases will eventually force the Supreme Court to confront the issue head-on. And when that day comes, all the groundwork laid in decisions like Heller, Bruen, and now Smith Wesson will be impossible to ignore. It's no longer a question of if, it's a matter of when and how decisively the court will act. What we're witnessing isn't just another legal skirmish, it's a constitutional reckoning. A unanimous Supreme Court decision has reaffirmed what many already knew. Rifles like the AR-15 are protected arms under the Second Amendment. That single truth is now echoing through courtrooms across the country. State bans that once seemed politically untouchable are being exposed for what they are: unconstitutional restrictions on law-abiding citizens. And while lower courts may stall or resist, they can't hold back the tide forever. Every word written by the Supreme Court matters. And in Smith Wesson, those words just handed defenders of the Second Amendment one of the most powerful tools yet. The question now is whether the courts will follow or whether the highest court in the land will have to remind them, again, what the Constitution actually says.